Good afternoon. My name is Juliet English, and you are live with us this afternoon with Michelle Zahir. We also have Michaela Silsby in with us from Spilling the Tea on Autism and ADHD. And we are having this very special live broadcast today called The Power of Many, because we're talking about this legal challenge in respect of the Children's Wellbeing in Schools Act, and how you can get involved, also helping you understand what it's all about. So before we go any further, I just want to see if I can share this fundraiser, if it's got to. There you go. Okay, so can we see the fundraiser?
Yes, we can.
Okay, so Michelle, I'm going to ask you to speak about it a bit more, because I'm going to probably trip over my words.
Right. So, for those of us who've been following what is now the Fix the Children's Wellbeing and Schools Act page, when it was previously Stop the Children's Wellbeing and Schools Bill, you'll have known that for the entire duration of the bill's existence, from the 17th of December 2024 until it got royal assent April 2026, we were actively campaigning against some parts of this bill which will override parental rights. Now, parents know their children best. It's been long established that it's the parent who decides where their child goes to for education, what education they have. It's absolutely always the child's right to education. That's fundamental. But it's the parent who chooses the school, who chooses to home educate, and acts fundamentally in the child's best interest. And that's been long established. As long as you're not providing harm, causing harm to your child, you are a parent doing your best as a parent. It's accepted you're acting in your child's best interest. This changes that position. So this enables, in certain circumstances, for the local authority to decide, no, we think it's in the best interest for your child to attend a school. And there is no appeal right. There's no sort of mechanism for you to go, excuse me, I'm the parent, my child's in crisis, and I actually want to educate my child in this way instead. So this is a fundamental shift of family life. We believe they've gone too far. They've gone beyond what the Human Rights Act allows them to do, and they're now interfering in your family life, in child's rights, in parental rights, in kinship carers, in carers' rights. So we think this needs to be challenged. Unfortunately, governments have unlimited resources of money because they have the taxpayers' funds, and legal challenges are not cheap. We tried all the mechanisms in the time. We wrote to MPs, we campaigned, we protested, we did petitions. So we tried every mechanism open to us before it became an act to try and fix it. It became an act. So we're now at the point of, to try and fix it, we're needing to turn to the courts. And legal challenges are expensive, unfortunately. So this is where we're at. It's a human rights-based challenge. The letter before claim has already been submitted. So we've got quite far, but we need to have the money to be able to continue the legal challenge and be able to take it as far as it needs to go to ensure that the decisions can be made to test whether the courts also agree that actually this is interfering in private and family life and has gone too far, or whether actually, no, it's okay for the state to do that. I know most people I speak to who are parents don't agree that it's okay. And in fact, I speak to many parents where the local authority have made poor decisions about their child's education. So they don't seem to be the right person. They haven't demonstrated that they are the right person to do that. And therefore, the reality is we need to get to about 250,000, but we don't need 250,000 right now. But right now, to feel comfortable with a legal challenge, we want to be around 50,000. But if we can get to 40,000, we're at a point where we're okay, but 50,000 would give us a buffer in case any sort of curveballs come in the early stages of the legal challenge.
Okay, and Michelle, you know, the person who's leading this case her name is Sarah, and she's going to be with us a bit later on to talk about things. But perhaps you can just explain why. Why is it a specific person that needs to lead this judicial review?
Yeah, because the way, unfortunately, you can't just academically challenge this. So you couldn't just go and challenge a piece of law, because we don't allow that. You have to have what's called standing. Now, that might be you as an individual, your family would be directly impacted. Um, you may have standing. It may be you as an organization would be impacted in a certain way, but the courts will ultimately decide who has standing. But you have to be more than a nosy neighbor. So you can't just go, look, this is bad law, I want to challenge it, because the courts will just say, on what grounds? You have no standing. So this is why you have to have the right sort of person to be the lead claimant, so that you can then get it before the courts in the first place. Because without the right person or the right organisation, you'll fail at the first hurdle, because you haven't got standing to bring the claim, even if everyone goes, oh, we think that looks bad. It's to stop just the courts getting backlogged constantly by someone who might be rich, who could just keep challenging everything they weren't happy with. So therefore, you do have to have a standing against the specific thing you're challenging.
And I just want to say, if you do want to donate to this cause, and this is partly why we're doing this, is to encourage you, please use this. You can use this QR code, and I will make sure the link is also underneath the live streams. At some point, I will get to it and make sure that you can see that. So this is, we want to actually watch this grow today, hopefully, and we want to encourage you to share it. And we're also going to be talking about ways that you can help to raise funds for this. It doesn't have to all be on you. We're not expecting you personally to donate huge sums of money, but we want to suggest holding fundraising events in your area. And we are going to talk a little bit about that as well. So I'm just going to stop the share there, right? And get back in here.
So there's lots of purposes. So the key purpose, if you can donate today, fantastic. Spread awareness. Let us know your stories. If you actually read through the Crowd Justice page, it identifies some people. You can go to Michael Charles's page. We're actively looking for some additional witnesses at the moment to help with this case. If your family meets those criteria, please reach out, because this is one, we need the funds so that we can take the legal challenge as far as it needs to go. Two, we need the witnesses. We know you exist because we're hearing the stories on a daily basis about how you've been failed and about how you've been ignored, or how the local authority has made the wrong decision in your child's case. So it's about awareness as well. And the last bit is, obviously, get a group of you together, fundraise, go and car wash, bake sales. There was a 11-year-old who baked some cakes and sold them. And £11, that £11 makes a big difference, because every single pound is just going to ensuring that we have a robust legal team, robust legal arguments. There's lots of really, really complicated constitutional law principles that have had to be looked up. The old law books dusted off to look at these really old principles, because we're going right back to the fact of saying, well, yes, Parliament is sovereign, and yes, you can make these acts, but hang on, have you gone beyond what your rights are over us? Because yes, we voted you in, but is this beyond what, as a democratic society, we would expect you as lawmakers to do? And so it's a very complex legal challenge, which is part of the reason it's so expensive. But to put it into context, if people look up the case for the proroguing of Parliament around Brexit, that went into millions for that particular case. So if you want to look into the context, like, oh, 33,000 sounds a large amount, 250,000 sounds a large amount. It's, unfortunately, complex legal stuff is expensive. And this isn't a challenge you can do without a really, really good set of legal brains to work on it. So that's unfortunately why it ends up being so much. And on that bit, should we maybe...
Well, I just want to quickly go back to what you said about needing other witnesses, just going back to this here. Who are we looking for? It talks about, we particularly seek to hear from families who may be affected, including parents wishing to withdraw a child from school placement, but concerned this may be restricted, parents who have experienced Section 47 investigations that were later dropped, families where local authorities have overridden parental decisions despite education being suitable, and parents of children in special schools concerned about future restrictions on choice. Your experiences may help provide the evidence needed to properly test this law. So that's what we're talking about there. Okay.
And should we lead on then so that people sort of understand a bit more with, we've got a video note from Michael Charles.
Yes, just hang on. I was just trying to find my way back to you, back to us. So let me get that video ready. So we have a video. So do you want to just tell us a little bit about how Michael Charles is involved? Many people are familiar with Michael.
Yeah. Well, Michael Charles has given so much time off his own back before now. Michael Charles surprised me by attending our first protest. We were fully aware of him in the next protest. He's spoken out about the implication for parents and the implication for children. And he, over 30 years experience in this field, he knows what the realities are of parents battling for the right education for their child. So he's in it from the heart as well as from the professional perspective. The next side of it is when someone decides they want to take a legal challenge, they have to contact a variety of solicitors. So it wasn't Michael Charles who chose to do this legal challenge. It wasn't up to him. The lead claimant, Sarah, had spoken to a variety of solicitors. Sarah, in the end, decided, and it's mutual because there are reasons why solicitors sometimes can't take cases on, but Sarah, in the end, decided Sinclair Law, Michael Charles's firm, seemed to be the best fit for this particular legal challenge. So she then formally instructed him, once he confirmed that yes, his law firm can take it on, they've got the capacity, she formally instructed him. So then the legal relationship started. And then obviously then it's Michael Charles's role to get the appropriate advice, do the relevant research, feedback, and then continue to take ongoing instructions from Sarah and the other claimants, because it's not just Sarah who's the only claimant, but there is always needs to be a lead claimant on the tin. So there are other claimants who, for whatever reasons, their names being public is not appropriate at this particular moment in time, which can include family circumstances and things like that, because we're talking about very sensitive family and children issues here. Whereas Sarah's from an organisation, so it's quite normal for an organisation to be very public.
Okay, so I'm going to go ahead and share this video from Michael. So just bear with me. Let's hope this will work. Can you see the video? Michelle,
I can see it. I'm just
okay, good. Okay, I'm just going to mute.
Hello, and thank you for taking a few minutes to listen to what I have to say here today. Many of you will know that over recent months I've been working on a proposed judicial review challenging certain provisions of the Children Wellbeing in Schools Act of 2026. And this is not a political campaign, okay? It's a legal challenge, and ultimately it'll be for the High Court to decide whether the legislation is compatible with the Human Rights Act and other legal principles. The government has now responded to the letter before claim that I drafted, and as you would expect, it strongly disagrees with the challenge and has instructed experienced public law lawyers to defend it. That's entirely proper, let's be honest. I've now had an opportunity to consider those responses with David Lawson, who is acting as barrister in the case, and he believes there are properly arguable grounds that deserve to be considered by the court. And I'm also grateful to others, including a KC who has indicated the willingness to assist if this case progresses. Our concern is not with the objective of protecting children. Everyone wants children to be safe. The legal question is whether some of the mechanisms chosen by Parliament are compatible with the Convention rights, including parental autonomy, family life, equality and proportionality. Those are matters which only a court can ultimately determine. The government says that the challenge is premature and raises a number of other legal arguments. We disagree with several of those arguments, and we're now working to finalise the grounds of claim before deciding the next procedural steps. One of the challenges in bringing public interest litigation is that it is expensive. The government has the benefit of significant legal resources, and we don't. Everything that has been achieved so far has been only possible because members of the public have been willing to support this case through crowdfunding. If proceedings are issued, Every contribution will go towards funding the legal work necessary to present the strongest possible case to the court. And whether you are able to contribute financially or simply help by sharing information about the case, your support is genuinely appreciated. And whatever the outcome, I believe these issues deserve careful judicial consideration. And the courts exist, let's be honest, to determine difficult questions like this about the limits of state power and the protection of individual rights. That is exactly what this case seeks to do. Thank you so much for listening, and thank you to everyone who supported the case so far. It is so appreciated.
Okay, so that was Michael Charles. Let me get myself back on screen, sharing about this challenge. And we are hoping you might be able to join us later on to answer some questions.